Respected, most honorable chief guest of this inaugural session, Professor Dr. R.C. Bobatra Guhai sir, our distinguished resource person, Professor Dr. Mohan Rao Bolla sir, chairperson of this workshop, Dr. Gautami Datta Bora ma'am, deputy chairperson, Pita Brahma ma'am, coordinators of both the colleges, IQAC cell, and my associate organizing secretary, and the distinguished participants from all the parts of India who have gathered in this digital platform to gain some knowledge and equivalently share something to the other co-participants. I, Prasenjit Brogagoti, Joint Organizing Secretary of this workshop, welcome you all to this 5 days national workshop on intellectual property rights, jointly organized by Internal Quality Assurance Cell of Dr. RKB Law College and Kokrajhar Law College. This workshop has been motivated to create some legal reasoning and to know something more than what we know till date regarding intellectual property rights. So, in order to know all these things, we have invited 5 distinguished resource persons from various parts of India who are having more than 30 to 40 years of experience in dealing with this particular subject. So, I'll not make it a lengthy part, but before going to it, I'd like to inaugurate the session by asking our Deputy Chairperson, Pita Brahma ma'am, to deliver her welcome address.
Thank you, Prasenjit. Good morning to one and all present. My name is Pita Brahma, Deputy Chairperson of this workshop. On behalf of both the colleges and organizing committee, I take the privilege to receive and welcome each of you to the 5 days national workshop, jointly organized by IQAC cells of Dr. RKB Law College and Kokrajhar Law College, media partner latestlaws.com. At the onset, I would like to take the opportunity to welcome Honorable Professor Dr. R.C. Bobatra Guhai sir, the Advocate General, Government of Assam. He was also a Dean, HOD, Faculty of Law, Guwahati University. And thereafter, he had joined as the Advocate General in the year 2017 November. He is an eminent teacher and also a learner of law. Respected today's speaker, Professor Dr. Mohan R. Bolla, Principal, Christu Jayanti College of Law, Bangalore. I welcome you, sir, to our 5 days national workshop and thank you for accepting our invitation as an invited speaker. I would also take the privilege to welcome all the speakers, Professor T. Ramakrishna, Professor of Law and Chair Professor IPR, NLSIU Bangalore, Dr. M.N. Bhimesh sir, Senior Advisor ALMD Legal Advocates and Solicitors Bangalore, Professor Srinivasulu sir, Professor of Law, National University of Juridical Sciences Kolkata, and Dr. Nilotpal Deka, the Advocate of Guwahati High Court. Respected Chairperson and my organizing team, and heartfelt gratitude for putting up a thoughtful event for the students, teachers, and all others. I take the privilege to welcome our participants, including my student friends and learned faculties, and all the persons involved in other kind of employment for participating in this 5 days national workshop. The main objective of this workshop is that, as we all know, intellectual property rights deals with the laws and safeguards to provide protection and recognition to the creation of human intellect. Because we as human would want to develop, create, invent, or author some writing, sculpture, software, designs, etc. But at the same time, we must also know that we can claim protection for those creations and obtain unique identification. Therefore, this platform is being created to give awareness to the persons those are interested in knowing the available measure to protect and recognize their work. Also, this is to aware the importance of subject IPR and encourage the human intellect to create and contribute to the society for the growth of the economy. Hope this national workshop will help each one of us and understand the various aspects of IPR laws. Best wishes to the participants, and I hope that each of one of us will be able to successfully complete this workshop alongside abiding all the rules and regulations. So thank you and welcome once again. Thank you. Namaskar.
Thank you, ma'am, for beautifully addressing the gathering by also stating the object of this particular workshop. So now I'd like to invite Dr. Monomita Paul, ma'am, to start with Saraswati Bandana so that we can start with this workshop properly. Sorry for the inconvenience. Actually, there are some network issue in our area, so we could not have heard. So, whatever it may be, thank you, Monomita ma'am, for your effort. So now I would like to request our chief guest, Professor Dr. R.C. Borpatra Gohai sir, Advocate General of Government of Assam and former HOD and Dean of the Department of Law, Guwahati University, to address the gathering.
Good morning to all. I first express my sincere thanks to the IQACs of RKB Law College, Dibrugarh and Kokrajhar Law College, Kokrajhar, for giving me this opportunity to be a part of such a national academic discourse. I'm highly delighted and also congratulate both the instituting such a national seminar on this important issue of intellectual property rights. To my mind, as an ordinary person, intellectual property right is a right. It encompasses everything that human intellect creates. Here again, as a student of law, out of my long experience being associated with the law for the last 40 years, my realization is that we will have to look and approach this issue from two dimensions. One is the conventional dimension or the hindsight approach of materialistic aim. Second is the far-sighted approach of creative thinking. That is what is needed at the present context. Even the University Grant Commission is also trying to bring such an intellectuality or creativity in the line of thinking, line of doing research, and line of creating, generating, and innovating something new in the world. So in this, when you talk of intellectuality, it speaks about a perception. It isn't based only on logic, because logic is an approach of hindsight. Whatever is in existence, if we are going on analyzing, that is what 95% of the academic in the higher education we people are doing. But then we'll have to change this approach, an approach towards a perception of new ideas, new innovation, new generation in all fields, and especially in this intellectual property right, it is most important. Knowledge is important, but there is a ladder of knowledge. As an academician, we must approach to that. And that ladder starts with academic knowledge, being exposed to different types of literature, then experience, being associated with learned people. Then after that, we'll have to climb to the higher level. That is the level of realized knowledge. And after that realized knowledge, we should try to climb up to the transcendental or the spiritual level. That is what is needed today. Now, the mechanism through which we are trying to discuss on different issues with this digital process, it is compelled by the course of nature. As because we are not giving much emphasis to the spirituality of environment, such is the result we are facing with. But then the contentment that the science and technology is making us advance, and that is why only on the materialistic perception we'll have to go in the process for the future. And that approach will have to be changed. It is a reminder by the course of nature. And we call the wisdom, what is wisdom? Wisdom is act according to law of nature. Human beings are creatures of the nature, and we will have to maintain that. And as because we are going beyond our limit, these are different types of warning we are getting from the nature to be content with. Second, that intellectual property rights, can it be approached from human rights perspective? To my mind, yes, it can be and it should be approached from human rights perspective on two domains. In the international level, we are talking about human society. There are different types of efforts to pacify the human mongering tendency towards destruction, towards materialistic gain and prevailing over by one over the other. And that tendency is to be resisted. And that is why in the international level, so the first Declaration of Human Rights, Article 27 of that, along with 26, right to education, it speaks about that there must be an environment where moral and economic rights of every individual, and including these intellectual property rights of every individual, should be well protected. And that is the international norm based on which the national level laws are to be molded. Secondly, the unsuited laws, then also the WTO, World Trade Organization, and also the WIPO, WIPO. These institutions are tremendously endeavoring for harmonizing the situation and also inculcating the spirit of humanism in every human being across the world. That aspect is important. While our constitution was drafted, these things were taken into consideration at the universal international level. And the preamble, which speaks about that we are going to form into a sovereign socialist secular democratic republic with certain objectives to be made available to every citizen: justice, social, economic, political, liberty of thought, expression, belief, faith, and worship. So that thought process is included in this particular discourse. I think the learned scholars, resource persons with deep knowledge will definitely highlight to this, and also the participants will also augment their thinking power in such a way that this becomes beneficial to each and every person, poor or rich equally, black or white equally, in all perspective in the human society. Now, coming to the national perspective, as I mentioned about, the preamble is speaking about thought, liberty of thought, then equality of status and of opportunity. It also mandates for fraternity, assuring the dignity of every individual. So that creativity must be oriented towards the service to be made available to each and every human being to live with a dignity, live with dignity and honesty. That aspect is to be taken into consideration. Now, coming to the international law obligation, Article 51 of the Constitution, primarily 51C, the treaty laws, that is to be adapted into the Indian system. And to support that, Article 253 of the Constitution, it speaks about that the Parliament has a responsibility for incorporating the ideas of international treaties and documents which India have entered into and ratified to be brought into a national legislation. And with reference to this, says in the 7th schedule, if we go to item 10, 11, 12, 13 and 14, and also item 49 and 97, to be in brief. So based on that, we will have to formulate the laws, and academics will have to dwell upon doing fundamental research on is how to develop the intellectual property right culture in our society. Then I think based on that, the lawmakers will definitely make such type of law in the near future, and all the Indians will be well protected, and Indians will be a guiding factor to the rest of the world. Now, Article 300 capital A, after the 44th Amendment of the Constitution, the right of fundamental right to property has been withdrawn, and it has been brought under the principles of eminent domain. There also, even if it is not expressly provided, but the interpretation of the Honorable Supreme Court, which becomes a law of the land under Article 141 of the Constitution, it speaks about intellectual property rights to be included in that particular article. So we'll have to dwell upon, and basing on different dimensions of the intellectual property rights. Say, for example, in the intellectual property rights, it can be divided into two parts. One is the industrial intellectual property rights in the domain of trademarks, patent, designs, geographical indication, protection of plant varieties and farmers' rights, and also the biological diversity. These aspects, say, for example, from the Stockholm Conference of 1972, then Nairobi Conference, and also the Rio Art Summit. Based on that, we are bringing those principles into our national legal order so that these rights of these people, all the indigenous knowledge, traditional knowledge, those will also be encompassed. And also the copyrights, especially in the field of arts, literature, music, and related, that those matters are also governed by this particular perspective. So based on that, I think if we proceed on in terms of the constitutional mandate, in terms of formulating new ideas, new research, because in the national level, the universities, especially the law universities, they should try to promote in the direction of the UGC mandate of the reformation of the higher education, the fundamental research. They should try to convert them into fundamental research programs, and after that, there should be a database based on which the judiciary, based on the dynamic approach of those research, and also the bureaucrats, they can update the policies for the betterment and protection of rights of those people who have created those ideas, and their rights have to be protected. Of course, within a specific period of time, it can never be for once for all. Specific periods are there. Say, for example, in copyright, during the lifetime of the person who has created the music, art, letters, or whatever that might be, and 60 years, up to 60 years of his date in the Copyright Act, especially Section 22, I like to mention about. But then I personally feel that I have limitation. I cannot go to in details because all the learned research persons will definitely dwell upon those areas. Simply, it is an appeal from an experienced common citizen of the country, being associated with the discipline of law and society, being deeply rooted to the social values. I make an appeal strongly to the resource persons and also the organizers and also the participants to dwell upon those areas for the remaining part of this 5-day program. And I think we can lead the country in a right direction so that in the future we can say to the world that yes, we are leading and you follow us. I congratulate and I express my best wishes for the grand success of the function. And with this, with a humble appeal that endeavor will be made for different dimensions of this present subject, which is very much important because the piracy, then many other things which are coming up, these are to be checked. And unless this society is making participation with the administration, with the policymakers, with the judicial process, I think the conglomerated effort can save us from any danger that we have been, in the near future, we are going to face. With this, I again thank all the resource persons who are invited, all the participants, and especially the organized, the IQAC of RKB Law College and Kokrajhar Law College, Kokrajhar. And with my best wishes, I conclude my speech. Thank you very much.
Thank you, sir.
Welcome.
Okay, so I can see other resource persons also have joined our inauguration ceremony. So good morning, Bhimesh sir. And Ramakrishna sir, Professor Ramakrishna. Hello, sir. Good morning. Okay. Sir, Bhimesh sir, if you would like to kindly speak few words before the participants and before the chief guest, sir, please, you may unmute yourself, sir.
Namaste. Very good morning to you all. I'm very happy to associate with this program with this both the colleges from Assam. It's a very well thought program. Just now our Advocate General has given the very meaningful insight to this program. Hope the next 4 days will be full of intellectual activity from these two institutions. My learned professor, Dr. Mohan Bala is already ready. Good morning to you, sir. Today is going to give you an overview of it and the judicial issues concerning, followed with other three personalities. My teacher, Professor Ramakrishna, is also there. Sir, namaste. And my colleague, Srinivas, will also be there. It's a well thought program. I congratulate Dr. Preeta for inviting us to this program. It is very happy occasion for us to associate with these two institutions and the youngsters, budding youngsters, the aspiring advocates from the northeast part of India. I'm very happy. I wish you all the best. See you day after tomorrow again when I address you on patents. Thank you very much.
Thank you, Bhimesh sir.
Thank you, Sanjit. A very good morning to all. It gives me an immense pleasure to deliver the vote of thanks for this inaugural session. Respected keynote speaker, Professor Dr. R.C. Barpatra Gohai sir, Advocate General Government of Assam. Respected speaker, Professor Dr. Mohan R. Balla sir, Principal of Christu Jayanti College of Law, Bangalore. Respected chairperson and respected Dr. M. Bhima sir, Senior Advisor, ALMT Legal Advocates and Solicitors, Bangalore, and other organizing team along with the enthusiastic participants who participated in this workshop. I, Duhita Sargiari, on behalf of the organizing team, take the privilege to offer my heartfelt gratitude to Professor Dr. R.C. Barpatra Gohai sir for your kind cooperation. We thank you for your inspirational and insightful speech that highlights the key importance about the subject matter, which will motivate the participants throughout this program and will be remembered. We are grateful enough for accepting our invitation within a short period of time and allotting us your precious time to amidst your busy schedule. So we appreciate your kind presence. Thank you, sir. My heartfelt gratitude to Professor Dr. Mohan R. Balla, sir, for accepting our invitation as a speaker. Thank you, sir. I extend my heartfelt gratitude to Dr. M. N. Bhima, sir, for your valuable speech. I would like to convey my thanks to the chairperson and the deputy chairperson for creating this platform in order to transmit the knowledge on IPR. With this, I end my vote of thanks. Now over to you, Prasenjit, for the technical session.
Thank you, Duhita ma'am. So, without doing any further delay, we are already running out of time. So, thank you all the resource person for joining us in this inauguration session. So now I would like to start with our first technical session of day one, which will be on the topic concept of IPR and judicial trend, a perspective. So I'm very happy and delighted to actually introduce the resource person of this session, namely Professor Dr. Mohan R. Bola, sir. Now, I'll just like to brief out his profile. It is just the gist of his profile actually. I'm not giving it the entire one. Professor Mohan Rao Bolla, sir, is born and brought up in the historic town Machilipatnam of Andhra Pradesh. He graduated in BSc from Nobel College of Machilipatnam in 1981. After that, he got his bachelorate and master's degree in law with specialization in labor law from the University College of Acharya Nagarjuna University with a distinction. His dissertation on the individual dispute under the Industrial Disputes Act have been adjudged the best dissertation. Professor Bolla was awarded doctorate by Andhra University for his empirical research on the topic Special Economic Zones Act and the right of the project affected families. Professor Bolla has been serving in all the three regions of the combined Andhra Pradesh as principals of several law colleges before he became the professor of law in Christ University, Bangalore. Professor Bolla had also been associated with Jan Shikshan Samsthan, sponsored by the Ministry of Human Resource Development, Government of India, as program officer and director for many years. He has been a professor of law at Alliance University, Bangalore, prior to his inception as the principal of Christu Jayanti College of Law, where he is presently working. Being an experienced academician, he has been regularly contributing one chapter in the annual survey of Indian law published by the Indian Law Institute, New Delhi. Till date, he has published more than 30 articles in reputed law journals, including the Journal of Indian Law Institute, the Journal of Constitutional and Parliamentary Studies, etc. Professor Bolla has extended resource support in many national seminars organized by BSP, Mahila University, Kakatiya University, Andhra University, Osmania University, National Law School of India University, Bangalore, Andhra University, Acharya Nagarjuna University, and many more. He has also served as a member of editorial boards of several law journals all across India. Apart from it, Professor Mohan Rao Bolla is well known for innovative initiative in legal education, striving for achieving excellence. So, sir, we believe that this first technical session will be of immense value to all of us, and we will learn a lot from you, sir. So, the dais is all yours, sir.
Sabha Saraswati Namaha. Thank you very much for inviting me to this August session. The IQAC cells of RKB College and Kokrajhar College, especially my learned friend Ms. Preeta Brahma, and respected Professor Borpatra Gohan sir, Professor Bhimesh, Professor Ramakrishna sir, and all my Professor Mr. Harish, and Mr. Gautami Datta, and other distinguished intellectuals in this intellectual property session. As per the UGC norms, you have taken a very great initiative to impart and share knowledge with respect to intellectual property law with all the bent of intellectuality and intellectual qualities. And I appreciate that. And let us start the session. I'll be dealing with the basic aspects, and I'm not going to deal with very deep analysis of the intellectual property law, as it is a very vast subject. And now, the intellectual property law and various authors do not find place for defining an intellectual. That is a glaring issue. Generally speaking, an intellectual is one who knows the problems and how to solve them. That who raises the problem and solving the problems are generally considered as intellectuals. And the property they own, the mental capability, wisdom, as rightly pointed out by Porpatra Gohan sir, and the so-called liberty of exercising the liberty of thought when they initiate. With the advancement of time that Indians have an idea and ideology that we are living in this universe, Vasudhaiva Kutumbakam. We have intellectual property law developed in India. This Vasudhaiva Kutumbakam is considerably universal. It requires that there shall be universalization of intellectuality and dissemination of knowledge, and there shall not be confinement, and there shall be always fair use, not for any destructive purposes. And even Vivekananda, he is of the opinion that the oneness and the strong mental capabilities with the unique quality of yoga, which is now universalized. We have Vasudhaiva Kutumbakam to prosper. And we are talking about intellectuals, and among the intellectuals we come across several such great people, but for the odds they have, like Ravana. Ravana is the offspring of Tulsi Brahma, a great intellectual. He is a great artist, and he had written this Ravana Krita stotra of several stotras he has authored, and especially this Jatatavi Galajjala is well known. Sivatandava Stotra he had authored, and had there been the intellectual property confined to him, there could have been a case against even the Bahubali fame Rajamouli. And we have such plagiarism controversies with respect to several movies, and in this background, let us look into as to what is basically known to or the inclusive aspects of the intellectual properties. They include copyrights, patents, trademarks, industrial designs, geographical indications, and the traditional knowledge, among others. And the intellectual property, it refers basically to creations of mind, such as inventions. And very often even discoveries also may as well be taken into consideration, but there should be some innovative thought in that, whereby there can be recognition by the law, and that would be a legal creation whereby there would be protections made available to the particular person who invents them. And the greatest inventions are here depicted. And world's best inventions, it is said, including the paper and printing machine, etc. And the literary and cultural works, they also, or the intellectual properties, the artistic works and talents of various people also are included in those aspects. And they further recognize the designs, symbols, names, and images in the commercial arena, so that there will be some catchy idea and a hologram through which a particular organization can be identified easily, and there is a scope for business initiatives and propagation of ideas, advertisements, etc. And it also there has been recognition even by the judicial fraternity, and there has been several definitions given about the recognized talents as intellectual properties. As it has been rightly pointed out by Justice O. Chinnappa, an artistic, literary or musical work is the brainchild of its author, the fruit of his labor, and so considered to be his property, and that requires recognition and protection. And generally speaking, whatever that is done by these intellectual property laws is nothing but to recognize and extend protection for the intellectual properties. And then there are international conventions inter alia culminated by TRIPS, which is followed by the WIPO. And let us just watch a conversation organized by a panel discussion organized by the WIPO.
Hello and welcome to WTO Forum. Today's topic, the WTO's rules on trade-related intellectual property protection. The question, does the so-called TRIPS agreement strike the right balance between the rights of patent holders and the rights of national governments? We're very fortunate to have with us today two distinguished experts on this matter. Celine Chalperia with the Oxfam, she runs the advocacy office here in Geneva, and Harvey Bale, who's the Director General of the International Federation of Pharmaceutical Manufacturers and Associations. Welcome to you both.
Thank you.
Celine, does this agreement strike the right balance?
Well, Oxfam does not believe that the TRIPS agreement strikes the right balance between the rights of patent holders and the rights of communities who need to have access to essential new products and technology like essential medicines. And the biggest losers of this imbalance are the hundreds of millions of poor people who cannot afford medicine because they pay medicine out of their own pockets, and for them prices are just out of reach. we believe that the TRIPS agreement introduced very high levels of intellectual property rights protection, 20 years in fact, and that length was just not adequate to fulfill development needs in developing countries. And in spite of promises made to them in 1995, none of the big tangible benefits materialized. We haven't seen more research in neglected diseases that are prevalent in those countries, and that agreement has done nothing to make medicines more affordable and more available in developing countries. And all of this in spite of the gigantic needs facing those countries where, you know, today you have 39 million people living with HIV and AIDS in developing countries, and also you have big problems coming up with cancer and diabetes. The only silver lining is that there are some flexibilities in the agreement that help promote public health, but unfortunately countries that have been wanting to use them have been faced with a lot of political pressure or other instruments that have prevented them from using those instruments. So as a result, this imbalance has gotten worse with implementation. And again, the big victims of all of this are the poor men, children, women who just cannot get access to treatment, and as a result, die or have, you know, very prone disease.
Harvey, your perspective.
Well, thank you, Keith. Thank you, Celine. I think that we have to recognize that the conditions of poverty are going to be a problem that we have to challenge. The Millennium Development Goals are set up to meet those challenges of poverty, access to medicines, healthcare. But TRIPS is not the problem here. TRIPS has an enormous range of flexibilities. We first have to recognize that until 2016, the 40 poorest countries in the world don't have any obligations to adopt these patent rules. Some have. They've decided to opt on themselves as a result of different agreements or their own legislation. But I think that to say that somehow the TRIPS agreement is responsible for lack of access to medicine, I think lies in the face of a number of facts. The World Health Organization has estimated that about a third of the world's population lack adequate access to quality medicine. And this is a very serious problem, but this has been a constant over the past 30 or 40 years. And in fact, countries like India, where the patent protection has been the weakest, has been among those countries where the lack of access has been the greatest. What we face today is a problem that people who earn less than $1 a day cannot afford any medicines. They can't afford generic medicines. They can't afford patented medicines. They can't afford new medicines. They can't afford old medicines. So what we have to do, and what a start that has been made, is that organizations like the Global Fund, the Global Alliance for Vaccines and Immunization, are filling these gaps. They're filling these gaps with novel vaccines and novel drugs that have been produced as a result of the patent system. What we see in India today, and in China, Mexico, and Korea, is the emergence of countries in the developing world who are inventing, developing, and producing these new medicines. So the TRIPS agreement is going to revolutionize the range of medicines that are available to poor people and to rich people. And this will be an enormous positive benefit to the developing world. So in a word, I do think the TRIPS flexibilities are there, and they are important.
Does he make some points there that are worth considering, Sophie?
I think it's a false dichotomy to say that the problem of access to medicine is not linked to prices of medicine, it's linked to other factors. It's obviously both. I mean, I was a few years ago in a hospital in Mali where you had doctors and nurses put an empty, drugs cabinet, and basically families had no other choice but to see their relatives die or to go out and buy those medicines. And if you look at countries that have been extremely successful, for instance, fighting against AIDS, yes, they have given money to those treatment programs, but they've also done so in a cost-effective way. And to do that, they have been forced to do compulsory licensing because they were unable to get reasonable prices from patent holders. And that's the case in Thailand, and that's the case in Brazil. So I don't think it's one or the other. It's both that will get medicines for all.
Well, Saila, I think it's important to recognize that 98% of these essential medicines, which are identified by the World Health Organization, have been off patent for decades. So the key drugs for diarrheal disease, lower respiratory disease, people are dying by something like 4 million people a year of lower respiratory infections. None of these important medicines are on patent. All of these medicines are off patent, and in fact, we look at the prices of AIDS drugs in Africa today. The prices of these novel AIDS drugs are cheaper in many of the African countries than the generic versions that are made by the copycat companies in India and elsewhere. Compulsory licensing hasn't been used in Africa because it's simply not needed. Companies are offering these drugs at no profit, at below profit, zero profit, at cost below cost. So I think that countries like Thailand and Brazil, which are among the very few countries who have actually used the flexibility of TRIPS, have those rights. But at the same time, I think most countries are deciding, like those in Africa, like countries in Asia, most other countries in Asia, are developing, in fact, their innovative systems, generating higher levels of GDP, faster economic growth, are able to pay for more drugs, as well as developing their own industry, developing these new drugs at home. So I think it's important to recognize that the system is a balance. For countries in Africa, the poorest countries in Africa, the poorest countries in Latin America, the TRIPS system is simply not very relevant because these medicines are off patent. Most of the companies that I know who are developing AIDS drugs don't even patent their drugs in most countries in Africa or the poorest countries of the world. It's simply not economical, it's not relevant, and so I think the question of access has to be looked at in a balanced fashion. It has to be said that at the end of the day, we've got to do much more in infrastructure, much more in financing, because these problems predate TRIPS. They predate them by decades.
So,
with these remarks from the International Forum, what we generally can take home is that the respective member countries are expected to take their own measures in order to ensure that there will be free access to medicine and off patenting, and there shall not be any compulsory licensing insisted in order to ensure that there will be the intellectual process of inventing new drugs, especially the immune systems, which could counter the pandemics even, and that is what has been highlighted with respect to TRIPS and the other intellectual property expositions with respect to in the international arena. And we have several conventions, and which have been mentioned by Bor Patra sir, and in India we have the intellectual property with respect to the constitutional recognition through the freedom of expression, then freedom of trade, even the personal liberty that is guaranteed under Article 21 is also associated with it. And Parliament has been empowered to enact laws relating to patents, inventions and designs, copyrights, trademarks, or even merchandise marks, especially in view of Article 246, the enabling provision, and the Schedule 7 specifically, and in the list 1, item 49, then item 31, they all relate to these the provisions enabling the state to enact the laws, and list 2 and 3 also contain several provisions, several items through which there can be a law enacted, whereby there can be an effective regulation and no scope for exploitation of the inventors and the property right, intellectual property right holders, and the various enactments which are associated with this intellectual property law, the multi-pronged, I say, or these legislations which are enlisted here, including the Trademarks Act in 1999, the Designs Act 2000, Copyrights Act to start with in 1957 itself, then the Patents Act 1970, Geographical Indications of Goods and Goods Act 1999, and then Trade Secrets Act. Trade secrets covered under the Companies Act 2013, then the Semiconductors Integrated Circuits Layout Designs Act 2000, then the Protection of Plants and Varieties of Farmers Act, Rights Act 2001, and the Biodiversity Act 2002. These are all the enactments which are associated with the intellectual property law in general. And the violation of the intellectual property rights also can be read into the violations and treated as violation of the fundamental rights, especially the freedom of speech and expression. And the Bhavishwatar Bhut movie is an example. And let us just watch the trailer of that Bhavishwatar Bhut movie. Perhaps you all
Phantoms and country ghosts.
have the knowledge of
বাংলা
understanding it
আপামর
fully.
প্রসিদ্ধি আত্মা এবং প্রিয় ভূতদের নিবাস। আমাদের বেঁচে থাকাটা ক্রমশ কঠিন হয়ে যাচ্ছে।
এই কোথাও অন্ধকার, কোথা যাবে ভূত সকল? এই ব্লাডি সিটিতে আর কি আছে? কারণ বর্তমানে ভগবানের ভয় না পেলেও there are some people যারা ভূতকে ভয় পায়।
ভূতেদের নিয়ে কিছু এখন চাই করবেন সেন্টিমেন্টাল হতে।
কথা দিয়ে করলে না দিয়ে
এই গল্পটা না করলে বাবা ওদের খাচ্ছে না।
সব রক্ষে খামোশ বস নামটা না তুমি একটু ভাবো বুঝলে।
David say, ভবিষ্যতের ভূত।
So this Bhavishwatar Bhut movie has been in question before the Supreme Court in illegally creating private limited versus government of West Bengal. Because in a dramatic way, there has been criticism against the politics, especially the government appears to have been getting offended, and there has been an extra constitutional or extra legal ban imposed on the movie. And finally, the Supreme Court has come to the rescue of that and recognizing the intellectual property rights inter alia with the several rights, including the rights that are guaranteed under Articles 14, 19, 1A, 19, 1G, and even 21. And finally, the court has also imposed a huge penalty against the government, and in order to ensure that there will be effective protection for the film exhibitors and especially the producer and his team, they could get the justice rendered in the instant case. And then we go to a particular time when the Supreme Court was confronted with the question of intellectual property, especially the copyrights. And this particular issue is also again a movie wherein Mohan Sehgal, he was allegedly copied the theme of R.J. Anand, who had written actually and played an act, a drama which has been exhibited in several areas, including even Kalapeta. And R.J. Anand, he moved, and the court, and he could not get justice rendered at any stage, even before the Supreme Court. What the Supreme Court was looking at, we'll just observe after just going through a clip of this particular movie, which is in question. The movie is known for the provincialism and the disintegrating factors of casteism and the language, etc. And the central theme of R.J. Anand's drama also was the same. And the narration of the story, little variations are found, and it is not true to spirit, an exact copy of what has been written by R.J. Anand, which is captioned Hum Hai Hindustan. And finally, this hero, he faces several problems in getting even a room for rent. And every house owner, he tries to give only to a Bengali, a Madrasi, etc. And the hero, he dupes himself as a Madrasi to get into a house, and that actually paved the way. This picturization by Mohan Sehgal, who has presented the movie, that has been in question before the court, and the court has watched both the drama, or it had read the drama Hum Hai Hindustani and Hindustani, and then Mohan Sehgal's movie also. And when the central theme was copied, there should not be any objection according to the court. And the copyright protection cannot be extended to the central theme. But if there is something like a Xerox copy of the total scenario and everything, if it is copied, there can be objection, and the copyright's extension is possibly made available to that extent only. And in a way, the way the court has been interpreting, it has established a trend that the theme, copying a theme cannot be objected even under the Copyrights Act. If one author, if he strenuously, or his central idea, even when it is copied, there was no such objection raised by people by and large. The wisdom of the court was exhibited in such a versus that the plaintiff has not proved by clear and cogent evidence that the defendants committed colorable imitation of the play, according to the Supreme Court, to violate the copyright of the plaintiff. That is to say, suppose if we take a textbook, the cover pages are only to be changed, and if there is a release of a book in such a way, that can be considered as violation of copyright, or that kind of issue only can be protected, and not when there is by and large copying of a particular central theme and even the play. You see the provincialism, which is the idea, central idea is not protected according to the court. That is the trend with which there has been initial ideas. And as far as performing rights are performers' rights are concerned, the Supreme Court in Indian Performing Rights Society versus Eastern India Motion Pictures, there is protection available as far as the film is concerned to the producer, and outside the film, the film, the particular lyricist or any such artist, they have the personal right extended to those under the Copyrights Act. That is what has been held, and the Justice Krishna has aptly explained by taking an example. A film may be cast to be exhibited as a film, but the pieces of music cannot be picked out of the soundtrack and played in the cinema or other theatre. To do that is the privilege of the composer, and that right of his is not crowned in the film copyright except where there is a special provision such as section 17 proviso C. So beyond exhibiting the film as a cinema show, if the producer plays the songs separately and attract the audience for other reason, he infringes the composer's copyright. So composers and the other artists' rights have been duly recognized with the kind of interpretation, a purposive interpretation that is taken into consideration by the court in his concurring judgment. Justice V.R. Krishnaiyer has explained the rights of the performers by way of an example as depicted in this particular case and slide. And then we have the conventions which we were talking about. They include Paris Convention, Barbie Convention, and then TRIPS agreement also. And India has been a signatory, and there has been several changes with respect to the Patents Act in 2005 in June with the TRIPS amended TRIPS agreement, and the Copyrights Act in specific terms it provides for registration of literary, dramatic, musical, sound recording, and artistic works in order to extend the protection in pursuance of even the international conventions. And we have Eastern Book Company case wherein there was a controversy with respect to the publication of the published or permitted judgments and the edited versions of the Supreme Court cases which have been taken by the defendant company in the instant case, and they were releasing the CDs and they were trying to in a way commercially exploit the strenuous hard work of Eastern Book Company and the editors of Supreme Court cases. As to what is generally done by the editors of the journal, like a standard journal like Supreme Court cases is even narrated at length, and pertinently the court was depicting as to what is the fine-tuning work that is done in paraphrasing various aspects, and even it was of the opinion that putting paras and contributing the head notes with the relevant issue that is to be identified, even the identification of the ratio decidendi or the principle established in a particular case is a crucial task of a legally knowledgeable person, and that has been recognized. And that kind of work, when it is done by Supreme Court cases, that particular part of the head notes and other things cannot be duplicated and directly taken for the commercial exploitation of the defendant. That was what was the comment made by the Supreme Court, and therefore the particular case has been partly allowed in this historic judgment in Eastern Book Company case. And I think the students they deserve to appreciate better, and may aptly note down what has been laid down in the instant case. And the objection raised was with respect to the copying of the sequencing, selection and arrangement of cases coupled with the entire text of copy-edited judgments, as published in the appellant's journal, namely Supreme Court cases. So in verbatim, what is to be taken home with respect to this particular case is that when a person produces something with his skill, labor, and it normally belongs to him, and the other person would not be permitted to make a profit out of the skill, and that comes within the ambit of the modern plagiarism. That is to be appreciated by us all, and that to that extent there is recognition and protection of the right according to the court also. The so-called originality, according to the Supreme Court, is lacking with respect to the direct depiction of the facts, etc. And on the other hand, we have the Patents Act 1970, which has been modified even in tune with the TRIPS amended TRIPS agreement, and the famous or the leading decisions with respect to the duplication of drugs, etc., are here taken as samples. Drugs Inspector versus Physicum Labs. Actually, sildenafil citrate, which is the famous Viagra. It is a generic form. It is taken by Physicum Labs, and without license, that they have been manufacturing this Osamon Fort in the and that has been taken to the notice of the Supreme Court, and that was considered as a mere duplication and in violation of the Patents Act as well as the Copyrights Act, and it was a patented drug, and of course the generic form of that is only captured, and just it is duplicated in the form of Osamon capsules, and that was objectionable to the drugs inspector, and the drugs inspector identified that, and without license when that business was being done, exploiting the generic form of even the drug, that was objectionable, and that violates the Patents Act and sections, especially sections 1827 and even 1827 of the Drugs and Cosmetics Act also, as there is compulsory licensing that is provided under these acts. And then we have the leading Novartis case, on which we have a great discussion or a panel discussion that was conducted in the news hour.
We have a straight 3 versus 3 divide on this very important subject. Dr. Prabodha Ganguly, CEO of Vision Intellectual Property Rights from Mumbai. Kewal Handa, Chairman of Medibiz and former Managing Director of Pfizer, with me in the studio. Thank you very much for coming. Dr. B.S. Ajay Kumar is Chairman and CEO of the HCG Group of Companies. He says it's a short-term benefit for India. I support patents only for the short term. Dr. Samir Kaul says government should have stepped in earlier because prices should be negotiated. Playing a very critical role, counsel and lawyer for Cipla, Pratibha Singh, and senior advocate and director of the Lawyers Collective, also a lawyer for the Cancer Patients Aid Association, Anand Grover. Sir, my first question is to you, Mr. Grover. You are very clear. You are saying companies like Novartis are only interested in profits at the expense of Indian patients. Can you elaborate your position, please?
First of all, if you look at the present case, Novartis did not invent this drug. This drug was invented through public funded projects by a person called Brian Drucker in the United States. This is an orphan drug. They got tax breaks. They did not even put even $400 million for the whole of the marketing, but they reaped $1 billion in the first year. This is not an invention. There is no innovation in it, and the Supreme Court has rightly said that this is a
drug which is hit by 3D. It's just a new form of an old drug. Either doesn't deserve any patent. Most of the companies in the US and Europe, North America and Japan, 76% of the drugs are those drugs which are new forms. These are the ones that are being patented. Therefore, in India, we brought in 3D, which says the new forms of known substances should not be patented. And this is the case of that time. The Supreme Court rightly rejected the claim of the Novartis company on
the other side,
which is the drug.
On the other side, you have two gentlemen, with contrary positions. I'm going to come to Dr. Prabhuda Ganguly, who actually supports these patents. He says that because of today's judgment, innovation may not take place, and Indian patients will be, worse off because of this. Keval Handa does not agree with this profit-making motive thing. Tell me, Mr. Handa, here's the situation. This drug called Glivec. In India, it is available. A patient can spend some 7,000 or 8,000 rupees a month and use this drug. Kidney cancer patient. Tomorrow, what answer will you give to a kidney cancer patient who would overnight, had the judgment been different, have had to sell over 1 lakh of rupees? Where would the money come from?
At also, this particular drug,
yes,
Novartis has given $1.7 billion of the drug free to the patients in this country. 95% of the patients get this drug free. I think, and the balance 5%.
What's the guarantee they'll keep getting the drug?
They are getting it for so long. And I think this data point that this drug is 1 billion in India is not true. So I think we need to get our data facts.
No, you answer my question here. My question is that suppose
I'm sorry, this is not correct.
You want to contest? Okay, go ahead. Anand Grover, please contest. I'm coming to Pratibha Singh also, please.
No, because this data was contested by us in the Intellectual Property Appellate Board. Novartis did not rebut what we said. They have no answer, and this is data from Novartis itself. And this can be so-called program which is called GPAP. It's a fraud. They know it very well. That was also contested by us. They did not rebut it. So please do not raise issues which have not been rebutted by Novartis in the court. Don't use this television medium to push their agenda.
No, I am not pushing anybody's agenda. This is a public knowledge. They have made.
You are.
They
you
have
are because you are not. You didn't have the chance. You had a chance to rebut it. You did not do it. And don't spread those false notions across television.
I don't agree with you. 16,000 patients are already on this data, on this drug. And if you look at the value of this drug in a
they are there only because you want to push that agenda.
No, I don't agree with you on that point. But the broader issue
we have patients who are getting free drugs also.
The broader issue still remains. The broader issue still remains. That 3D has not been neutralized by the
No, the broader issue is very simple actually. Samir Khan wants to come into the debate. The broader issue is this, that today there is a person who is having end stage or second stage or third stage or first stage, whatever, kidney cancer. And he needs this drug. Now, had the Supreme Court verdict been different today, he would have to find a way to get 1.5 lakh rupees a month to survive. I want to know the argument against.
Why are you penalizing a pharmaceutical company for lack of healthcare safety net?
I am sorry, but the reality in India is that no government of India will pay a patient 1.5 lakh rupees.
No, there
to get that drug.
There could be a different vehicle to get this.
Samir Kaul wants to come in. Samir Kaul, who's hyping this here? Me or the gentleman sitting next to me?
I think, gentlemen, good evening. As somebody who actually real-time uses these drugs on patients, we're not talking about kidney cancer today. That may be a similar issue, but we're talking about Glivec, which is used for chronic myeloid leukemia. A cancer, the patients of which young patients actually live after they get these drugs. So, in a background of patients who have got more access to this saving of their lives today, I have to make a couple of points very clear. That I'm happy on 3 counts. I'm happy on the fact that this judgment today, which I'm sure that our preeminent jurists will decide whether this 3D was applicable, and they actually had an innovative, increment or didn't have. But what I can tell you today is that this was an epoch-making decision today, because today this country is talking about patient rights. And it has actually achieved so much of public attention that we are debating it on national television tonight. I'm happy for that. I'm happy for the fact that many more patients below the poverty line will get access to this drug. I'm also happy for the product that today, if ever, that our own pharmaceutical companies will realize that they need to do more in the research and development.
Oh, absolutely.
But on the other hand, gentlemen, can I just last, can I leave you with a word of caution that rather than painting this whole thing as an East India company having come back and robbing our country, there are many products which are way away from our own research and development capabilities. And I'm talking about Herceptin, Trastuzumab, autoimmunoconjugates, Vector, and a whole lot of them for which there will not be a foreseeable R&D in this country.
Sure, there isn't. So what I'm talking about tonight. No, I'm talking about tonight. No, I'm talking. My question is. Yes.
Hello?
Yes, I'm coming to you, Dr. Ajay Kumar. Please tell me. You are saying if Novartis is such a.
However, my take on this particular case is that the court has aptly decided the case to the effect that there has been no innovation found in the particular drug that is alleged to have been doing good in the market about the cancer patients. And ultimately, what could be insisted is that all life-saving drugs must remain generic and there shall be no patenting permitted in order to ensure that a cancer patient, or which is the cancer is widespread all over even India and very much deep into the deep and pervasive into every nook and corner of several developing countries, which require free pharmacare or Medicare to be provided, despite the fact that there is no there is recognition implicitly taken into consideration under Article 21 of the Constitution, right to health guaranteed, but the health systems in India are not well set in order to ensure that free Medicare is provided, even at least with generic medicines. And this scenario, this Novartis versus Union of India is an aptly decided judgment in the particular Novartis case. And what is required is that there ought to be real invention in order to appreciate and get the recognition in the name of patenting, and then there ought to be the regulating measures in order to ensure that there shall be no exorbitant rise of the price, because the companies, once they get the patent of the particular drug, they tend to enhance the price, and that would not be accessible to the patients by and large, and that would definitely affect and imbalance the right to health that is guaranteed under the Constitution. And now after this Novartis, we have we have to consider the Bayer Corporation, wherein Cipla, the company which was said to have been manufacturing the generic medicine. And even in Novartis case, Cipla was one of the opponents which has raised the issue that there has been no invention. But the courts also have the constraint of having the special knowledge, and when we observe these things, there ought to be special tribunals at par with the National Green Tribunal, which would be dealing with especially the pharmaceutical issues, the drugs and health related aspects, and there ought to be experts sitting in the panel system developed in the tribunals in order to ensure that there will be good there will be rendering of justice by protection of the intellectual property rights. and the counterfeiting of the drugs has been condemned by the Supreme Court in the instant case. But of course, at the end of the day, it had laid down that there was a generic medicine and there was no violation of the intellectual property rights. And with respect to this Dr. Allo-Subden issue, which has come before the Supreme Court in Dr. Allo-Subden versus Yogesh Mehra, the Supreme Court was talking about the patent infringement suits and the counterclaims and claims, and what the distinction has made out by the Supreme Court, and while interpreting the section 64(1) of the enactment, and it had laid down that a petition by any person interested must be treated valid, and there shall be universal acceptance in public interest in the instant case. That is to say, if there is the question of locus standi viewed of, there is every possibility that people having knowledge and the knowledgeable people would take the issue before the Supreme Court, as has been done in Novartis case also. And the vistas of Novartis verdict has been taken to its logical end in Alois Ubden case. And then we have the Designs Act. The designs, with respect to this Designs Act, we have some leading decisions like Nandini Delux versus Karnataka Cooperative Milk Producers. In the instant case, the product and the design, when the product or the service that is sought to be rendered was different from that of what is being, what the fields are at variance. The Supreme Court in the instant case did not follow the verdict given in Ramaji Rao's T.V. Venugopal case, and there is a different verdict in a way given in this instant case, namely Nandini Delux. The kiosks of Nandini and the Nandini restaurant that were competing for the claim and counterclaim in the instant case, and of course the Supreme Court has stated that there is no copyright violation in the instant case. Then we have Satyam Infoway Limited, wherein the SIFI network was in question, and the SIFI Networks Limited, which is a latest company or a small enterprise which has been started in the arena, and Satyam Infoway, it had long ago registered, and of course the Supreme Court, speaking through Justice Mapal, has rightly in a way stated that the first come first served basis principle may be applied, and thereby that was a different case which must be taken into consideration. In this T.V. Venugopal versus Sushodaya Enterprise, as you are very well aware, Inadu sandal sticks or incense sticks, they were manufactured by T.V. Venugopal and Company, and Sushodaya Enterprises is having multifarious areas of trade, but the newspaper is very much well known, and mostly in Andhra Pradesh, and it is also being extended to all other states, but the name and the design, that particular design of Inadu was in question before the Supreme Court, whether there was a violation of the Copyrights Act when there was a different product with a different package, but though it is shown to have been with a different design, Inadu in the same way on a green pack, even resembling that of Ambika Agarbatti, there was that pack. In that pack, Inadu Agarbattis were made available, and the business was running so well, and there are several other products in the name of Inadu by several other companies. And Inadu, the nomenclature of Inadu, its meaning in Kannada and Telugu, that has also been compared, but as the name is so catchy and it was associated with Ushodaya Enterprises, the Supreme Court was of the opinion that that must not have been used in verbatim, and the same design must not have been used by TV and Gopal and his company. Welcome back, friends. Prasenji,
Huh.
can we continue?
Yes, sir, we can continue. All the participants are all available.
Okay. And this codex, though it is associated, there has been some issues with respect to the delay in taking up the cause, depicting or giving importance to lex vigilantibus non dormantibus. Based on the technicalities inter alia, the case has been decided in favor of Cody Distilleries, and the trademark Cody was the Peter Scott was said to have been duplicated by the other Scotch Whisky Association, and that was with respect to this Cody Distilleries case, and the protection of plant varieties, etc., and the protection of the protection extended to the companies which manufacture products like lace and the so-called fine variety of potato they grow, and they take the services of the exploit, even we can say exploit the services of the farmers, and they were suing the farmers for growing the so-called crop of the potato, the finest quality of potato that has been grown by them, and there were issues like that which would even have a deep rooting effect and impact on the intellectual property issues and vis-a-vis the traditional knowledge, and they indeed depend upon the farmers and the growers, and they do not have the possibility of having the regrowth taken by them, and that is a pinching area with respect to the or in a way the antithesis of the intellectual property law, because there is no such protection that is available when once the trademark or the patent that has been given to a particular company, and they generally try to exploit even under this enactment, which extends intellectual property protection to the companies. And it's similar to that of the so-called performers' rights that have been recognized under the Copyrights Act. There should have been such extension of rights available to the farmers who utilize the seeds and the BT varieties of the particular seeds, and there is a possibility to have the so-called regrowth that should be permitted. And then this in the instant the particular case named the Monsanto technology versus new seeds. On one hand, the Monsanto and other companies have been deep inroads into the local farmers' rights, and even there is an unfair what do we say, unfair competition among the companies, duping the farmers also, and with the advent of the so-called BT biotechnology advancement, there has been the rights of the people by and large affected very much, and in the Monsanto versus Nojigudi seeds, the Nojigudi seeds could win the case despite the fact that there has been some license that has been given initially, and there could not be a renewal of that. But yet, when it is manufacturing its own seats, the court has, in a way, lamented that the particular the case has been decided appropriately in recognizing the rights of the individual seats in the instant case. And of course, Coca-Cola Company and Distillery International case is also an example with respect to the trademarks and the imitating of the designs, and followed by this Bharat Glass Tube versus Gopal Glass Works, wherein the glass works were the designing of the glass works were in question before even the Supreme Court, and the so-called designs were to be recognized, and then once they are recognized, and the other company, when it is manufacturing such models, taking those models which have been recognized by law, there shall not be any duplication permitted, and the same technology must not be utilized. And finally, with respect to geographical indications, you are well aware that there are many places which are well known for several products, including saris, starting from Mysore silk, down the line several items that are recognized in the name of geographical indications. At least as far as geographical indications are concerned, they are deeply connected with the traditional knowledge, and there is protection given to the local indigenous people and the technology, and that is a plus point with respect to that. And the act actually it gives protection to the so-called item which is associated with a particular place, and the meaning extensive definition that has been provided under section 2E of the particular act is noteworthy. And very recently, there has been de-recognition, or what is that? The revoking of patent given to this turmeric, because it is a known substance in India, and in America there could be with the active initiation by the Council of Scientific and Industrial Research, there could be the revoking of the patent that has been granted. So with all this, I feel that we need to set our our IP house in order by being cautious about the duplications and the so-called plagiarism, etc. But all the time, what is required is that there ought to be trade or any such activity which is associated with intellectual property protection, not at the stake of having the endangering phenomena entering into that, promoting unhealthy competition and other things. And with all this, I thank each one of the participants, and especially for the organizers. I have a note of appreciation and a big thanks for accepting or having me as a resource person for the inaugural session on intellectual property. Thank you very much, and I think we can take some questions, before which I request Harish sir to supplement some ideas.
Good morning to one and all. Thank you, Dr. Bolla sir. Excellent presentation with good illustrations which are more informative to students and participants on this particular IPR workshop. Last minute I have been able to get into your thing. I think finally I thought I should be on this discussion. And I have 2-3 issues. One is see, under the patents, and a lot of things you have explained on the patents law. See, under patents, section 3K, 3D have an explicit bar on patenting of computer programs and some of the other areas. And 3D bars, pharmaceutical derivatives being barred from unpatentable, they have been said. I think with the present day scenario with information technology and a lot of other things happening with stem cells and other things progressing, I think government should think of amending this act to make these things also patentable. Well, that is one of my suggestions. The other one is in section 115 of the Patents Act, which provides the courts to appoint scientific, take on the help of scientific advisors and on technical issues to arrive at an opinion to expedite the disposal of the cases, which is seldom happening. It is the parties who will have to bring in an expert opinion and to decide their case. See, patent and life is limited. Once you, otherwise, till then the defendant enjoys the benefit of the delay of infringement of these patents. I think that needs to be expedited. The court should voluntarily really move towards a proactive initiative by appointing a scientific or technical expert from their own end, so that there will be fair delivery of justice on patent matters and than derailment of justice, which also is happening, and delay is causing derailment of justice itself by in itself. So I think these two sections need to be amended, keeping the need of the hour. And a lot of foreign applicants who are applying for patents is almost more than double in India when compared to Indian residents applying for patent, because there's lack of awareness of patent law, lack of awareness on trademark matters. Small eateries are fighting litigation. You spoke of the Ashika Agarbatis, the TV Venugopal's case. I am aware of Ashika Agarwati because I know Mr. TV Venugopal personally also. He lives in Bangalore South in Jayanagar in Bangalore, so I know his incense sticks issues. See, you need to see that there is more awareness in public, less of trademark registration, less of patenting is happening in this country because lack of awareness on this. They do not know the nuances of these things. I think we need to educate. We are a signatory to TRIPS under the World WTO. Lot of things. There are challenges in protection and enforcement of patent rights in India. That's the greatest challenge, especially in the pharmaceutical sector, like the ones you heard on Arnab Goswami's thing. Pratibha Singh is today. Pratibha Singh is today the High Court judge of Delhi High Court. She is from the first batch of the 5-year law course from Bangalore. Bangalore, who was in that Navaratis matter. She is the Delhi High Court judge at the moment. I think we need to create more awareness as the commercial sector people, traders, community, and organizations should come forward to patent and these things to obtain trademarks. I have a query on the trademark issues. Keeping slightly departing from the Whirlpool washing machine case. It's in the Whirlpool washing machine case, since it was a global name. After the company had closed down here in India, somebody else started that machine and even applied for the trademark. And there was a litigation between the global operator Whirlpool. Of course, global operator Whirlpool succeeded on the ground that it was a prior, they had a prior user right, and it was a global brand which was creating deception in the product. Deceptive similarities were there in the product, like Taipan to Jaipan. Products can be deceptive similarity. In a real estate field, assuming, I mean, there are two different companies who are developers. Okay, A is a developer, separate company. B is a developer, a separate company. A and B. B is the owner of a land, and which he offers to A to develop. Okay, B is the owner of a land as well as a developer, but he doesn't develop that land. He offers his land to A, who is also a developer, to develop this property. For the development of that property X owned by B, A is granted permission by B to use his company's name only to float another company for exclusively for the development of this particular project, the property called X. So once the A uses the name of B's company for a particular project, and he applies for trademark, okay, and probably gets the trademark, okay. Then B comes to know about it that my name, which I had permitted him to use it for a particular project, he has gone and registered it as a trademark. B files against A. In such a case, who will succeed in this matter? Who has got a prior user right?
Litigants like you and very big advocate brains only shall answer this question. Great question.
Yeah, this is for the benefit of all people.
That I understand. I explain that.
Yeah, I will just to illustrate this. I wanted them to. This is a food for thought question for all participants.
That's a good issue.
B is the B has a prior user right because he has licensed his name to A to use it for a particular project. Okay, so the original owner is B. It's only a licensee position of A who holds this name for that particular project only. He cannot go and register it and start merging A into B. No, he cannot merge his original company A into the registered trademark company of the X property which he developed and say I extinguish A and take up the project name company of X as my original company and start trading. You cannot do that because he will be the original owner. He has a prior user right for so many years, so he gets the benefit even if he goes into litigation on these things. I think this is what I just wanted to share. There are so many such litigations where prior user right.
Yeah. As to what I wish to supplement is, there is a possibility for a company like Satyam to register many domain names.
Okay.
Similarly, Whirlpool also, I feel that it is wrongly decided because once you do not have the business and trading, you have withdrawn from this particular country and your registered office is situated elsewhere.
Abroad.
You should not come in the way of the local traders initiating even that particular name. It doesn't matter, isn't it? If there is the quality and other things are well taken care of, the local traders must be encouraged. And what if you are given a particular license to use that particular name, you don't have that universalization issue, and once you are granted a patent in the erstwhile times when you had business in India and detriment to the interest of the local traders, the case must not have been decided. But the first come first serve basis, the courts must cautiously interpret the provisions of law, and purposive rule of construction must be taken into consideration, and you can't keep anything in the reserve for the usage of the brand names, designs, etc., and that would in a way adversely affect the societies and societal interest rather than anything else. Must be the primary
An individual interest.
Yeah. That's what I wish to just take. And the other point you were raising, I did not. You were dealing with
Section 115 of Patents Act.
That's okay. That is already answered, now, sir.
Yeah. That's 3K and 3D. The
3D actually, as far as 3D is concerned, the exceptions are left to the political will of the people, and what is appreciated is that as far as 3D is concerned, the patenting process in India is well appreciated and because it subserves the rights of the people and right to health and medication of the poor people, not only in India but in the neighboring countries. Almost all the member countries of the SAARC are getting benefited out of that kind of policy, and kudos to the wisdom of the Supreme Court for not in a position to identify anything with respect to that nuance or novelty issues with respect to naming a particular thing as innovative, and that is what I wish to. And Prasenjit sir, if you have any,
I have a last suggestion. Bola sir, I have a last suggestion. Information to all participants. And on the Colors Infinity channel, okay, there is a beautiful program which comes called Shark Tank. Okay, Colors Infinity channel. Okay, I think it may be season 7, season 8. I don't know. Shark Tank, SHARK, Shark Tank. Shark Tank is a beautiful program where you get to see how angel funding is done to startup companies by famous as corporate heads, so who are willing to fund and to startup companies. So in that process, you will know whether the process is under patenting, whether the process is being trademarked, or what is the product which will. I think people, the youngsters, and everybody should view this. You should view this. It's available even on the YouTube, the earlier seasons. They'll get a very good insight into how trademarks, intellectual property, patenting, and things happen across the globe. Thank you for having me on this.
Thank you, sir.
Thank you, Hari sir. Thank you, Hari sir, for joining Professor Balla sir. Okay, so there is a question from Anindita Dey. Sir, thank you so much for your wonderful presentation. I have a query. Sir, many teachers of colleges write textbooks and reference where ideas are taken from various expert sources. Sometimes it is acknowledged and sometimes it is not. Do you think it is a serious breach of copyright?
Yeah, at this juncture, that was why I was just a bit elaborating on what is being done by the Supreme Court in Eastern Book Company case. As far as this particular issue of writing books, I say, for example, I am constantly contributing one chapter along with Professor Anand Subramanian in Annual Survey of Indian Law on property law. What is expected from us is that we read all the judgments that are published in a given year, Supreme Court as well as each one of the high courts, relating to this particular theme, namely property law, which does not include intellectual property, especially Transfer of Property Act we take. And when we reread and research into various minute details that are deliberated in the judgments, and the points are highlighted, and a comprehensive report is made out in the particular survey, and there at least every such point which is generally recognized by law as a principle is highlighted and acknowledged, and that is the process. Even when you read even any judgment, the court, when it takes a particular idea, it definitely acknowledges, and that morale shall be maintained. And if there is an author who is not acknowledging it, that automatically goes into the plagiarism test in this nowadays being conducted, and it in a way slides away into that 20 to 30% plagiarism accepted. Okay. I think I have given the
yes,
answer.
Yes, sir, definitely you have given the answer. So there is another question from Dr. Ashutosh Kundu from Government Law College, Assam. He says that, sir, do you think that like basmati rice, turmeric, etc., India must amend patent law to preserve Indian products?
Definitely, and that way we need to keep in view of the local indigenous farmers as far as the particular kind of or variety of rice is concerned. we need to protect the interests of the local farmers, especially. So say for example, we have special provisions even recognized by the constitution for the northeast states. All the traditional knowledge that is there deserves utmost protection. And even unfortunately there are there is something very what is that, pinchingly in news, that there has been starvation deaths situated even in some of the key estates, etc. But for all such odds, there ought to be the farmers' interest, indigenous farmers' interest, rather than the company's interest, to be protected and preserved. And if there are any such variety that is produced by the innovation and ideas from the farmers, local farmers, that should be promoted. And we do not have proper protection available for the traditional knowledge we have widespread and rampant in India, and even the villagers are well known for very good farming techniques added by the institutions like the ICRISAT, etc. And that definitely is a valued point, I think.
Okay, sir. So there is another question from Manisha Devi. She says, as we see, and also it's very common that singers perform songs of various composers without their permission at various stage shows, and thereby earning lot of money. My question to respected sir is that whether in such situation composers' copyright gets violated.
Yeah, at this juncture, Justice Krishna's opinion is to be taken into consideration. And you are working and associated with a particular music composer, and in that team you are there. You need to sail with that particular team. And if there is recognition already, the copyright is given to a particular music composition. There ought to be continuation of that. And if you get, when once you are individually performing, then there should be no such a problem of identifying and protecting your right. And in this respect, we have that Crown Company case to be taken into consideration.
Okay. So actually, the question is something very related and very applicable to Assam, because during Bihu functions, the singers, any singer come and sing various songs which have been already composed by some renowned singers and composers. So I think so the question was directly relating to that. Because those singers earn lot of money by singing the songs of others. They do not have their any own composition.
Okay. And the public by and large, they generally criticize such things. See, a particular singer in a stage performance or otherwise, even if he imitates, that is in a way taken as a proud issue with respect to those people who had actually been the composer and who must have been recording. Has it been commercializing that in a way? Say for example, the particular composition of other singer, if it is duplicated in the form of CDs, etc., and I start doing business on that, that should be objected. Otherwise,
commercial exploitation.
Yeah.
Commercial exploitation.
Yeah. Stage performance must as well be appreciated. Earning money is an incidental task.
So another question: a person has invented something like oven.
I have already answered.
Okay.
Okay, because this kind of things you will come across more in Bhimesh sir's session.
Yes, sir. Exactly.
Because Bhimesh sir is well known for recognizing such local talents and very big innovations. Say for example, touching upon an issue like say the ear closures that have been in market now. That is an nuance idea by a pettiest trader. A pettiest trader, and it is not trademarked nor patented and nor recognized. And many companies are even without any brand name. You look at an year closure, and that's a very great innovative idea. This kind of things they must be encouraged. And as Harish sir was pointing it out, that a woven manufacturer should be encouraged to go to such a funding agency, and at least we have the encouragement, minimum possible encouragement, at least at the industry center. At every district you have a district industry center which will be promoting the startup units by offering training to run any particular enterprise. That is called entrepreneurship development training. That training also is desirable to be taken, though it is formally as to how to run a business and all that. Your innovative idea as a startup unit can be encouraged, and there can be very good push through even identifying good funding agencies, including the banks, private as well as public. They have that particular issue. Even now it is going on well, and when I was there in Jan Shikshan Samsthan, we were instrumental in organizing such training programs to thousands of youth who have enterprising ideas and artisan skills.
Okay, sir. So there is another question from Apurva Awasthi.
I have one suggestion. Sanjit, I have one suggestion.
Yes, sir. Yes, sir. Yes, sir. Most welcome, sir.
There is one. There is a society called Indian Performers' Rights Society in India. Okay.
Case is there.
Which Indian Performers' Rights Society in India, which protects the rights of collecting royalties of all composers, singers in India. So if you want to duplicate their song CD and thing, you must take license from them. Even to play some of these things in the pubs and bars, there is a society which will grant license, without which it will infringe the copyright, and you will be liable to cough up huge royalty for having misused and abused the other composers' songs by performing or playing it in the form of music and things like that. Even today in Bangalore, I am representing some clients who we take license to play music even in the pubs and bars and restaurants from this society. So this, along with this, I think students and participants should also look into Commercial Courts Act, which will give you some more insight into how these things matters as get disposed of through the Commercial Courts Act also and things like that. Commercial Courts Act.
Actually, the other idea sir was raising is the delay. Delay is omnipresent even with respect to these specialized courts and the tribunals. And further decentralization is required to ensure that that will be kept. Yeah, please go ahead, Premji.
Okay. So there is a question from Apurva Awasthi that he is asking that what is sui generis protection?
Sui generis.
Yes, sir.
Yeah. The matter of fact, this particular suit which has been raised, which involves general issues, and when once there is a suit raised, or this prima facie cognizance of a particular issue is taken into consideration and recognized by the court. And at this juncture, I wish some practical examples may be given by Harish sir. Sui generis.
Sir, what happens in practical side, unless the participants are able to go through some of these decided cases, is any example on this, they will not be able to understand the interpretation part of this sui generis. They need to look at, that's why I said only reading Patents Law, Copyright Law, Design Act, Trademarks Act, all these things will not be sufficed unless you read some of the the interpretation of statutes, interpretation of judgments, then the Commercial Courts Act, which is today playing a better role to speedy disposal of such some of these matters are happening to these things. So I mean, probably we can mail you some details on which to look up to and things like that, which will be more easier for them to understand. And
and to elaborate on that, sui generis is a unique quality with respect to which we need to take cognizance of that particular situation. Say, for example, what is objected to with respect to BT brinjal is that there are several unique qualities and varieties, as many as 17 local varieties of brinjal are there. If there is some more such a BT based item is projected for registration, there ought to be sui generis or identification of the and recognition of that particular quality item that is already in vogue and within the knowledge of the local people, and that the court takes judicial notice of it and proceeds to decide the case.
Okay, sir. So another question from Zahid Parvez. He is asking that can we patent symbol of political party and why?
That comes under the purview of not about the under the Patents Act, but that comes under the purview of the Election Commission.
Election Commission of India.
Election Commission takes care of every such thing, and when there is a similarity, etc., they will definitely object. But say for example, you have cycle, you have a bicycle as the party symbol of Telugu Desam party in Andhra Pradesh, and the same cycle may be accepted as a symbol for another political party in Bihar.
Samajwadi Party. Samajwadi Party.
I don't want to name that, but I'm telling you.
No, it's available on public. So, see, as far as Election Commission is concerned, when you apply for a thing, they will ask you to select the symbols which are not already obtained. So, like how you go for Companies Act for registration of your name. So they will tell you this is already existing, so please opt for some other thing. So like that, there will be such suggestion put forth by by way of objections from the Election Commission when they are going to entertain your application for registration of a political party.
Now, what had been in vogue earlier, Congress party used to have cow and calf as symbol.
Yeah, the original Indian National Congress had the charka, the weaving charka. Because even day before yesterday in Bangalore, if you had seen D.K. Shivkumar assuming office as president of the Karnataka Pradesh Congress, the flag which was handed over to by the former president to him was the one which had the charaka. Okay. Then it was having the cow and calf when Indira Gandhi's Congress was united with Devarajas and all were all one.
Getting it anyway. Things may be left aloof nowadays, because that was an era where even pious issues were there, and sentiments also counted. When you
see today, yeah. One more information: all wine stores, wine operators, wine stores, liquor people are banned from using names of gods. Earlier they used to have Lakshmi wine store, Venkateshwara wine store. Today it is all banned, prohibited.
It should be only Sukracharya wines.
So, a lot of them will not know this. That's why I am just putting it across for the sake of information.
Okay. The question from Arjit Kundu. He's saying, can you please enlighten the standpoint of law regarding folk songs, as happened recently in the famous Hindi song by Badshah? Are folk songs required to be copyrighted?
That's what actually folklores, etc. They come under the traditional knowledge and the cultural issues, and the cultural identity is protected even by the Constitution as a fundamental right. If it is an essential cultural identity and there can be tagging of that particular issue with the geographical indication also possibly, and the so-called identity, there is no crisis as far as that kind of recognition is concerned, and there is no legal objection, because when once you have a folklore typical to a particular area identified, and there are instances where they are encouraged, and they need protection, special protection to be given by the policy makers and the political leaders in that local area. They must take the right cause of those particular people and the artisans and the folklores. Say even in Andhra Pradesh and the neighborhood, almost all the southern states, you have Surabhi, the artists. They live one. They have only one task as an earning source also, or the livelihood also, is to perform dramas. They enact dramas and they play, and like that. Any folklore, as a matter of fact, must deserve the recognition and encouragement. There ought to be financial funding and recognition of artists. Recently, yesterday only, many so-called pop singers troops, they are almost claiming that they deserve recognition, and in this pandemic they are not recognized as artists, and they are not getting the benefits at par with those who are living under the poverty line, with the recognition cards given by the Andhra Pradesh government there, and they were making a hue and cry. This kind of thing, there ought to be extension of such benefits to the people. If they are even at this juncture in a pandemic situation like this, they deserve equal recognition and protection at par with the common indigent person.
Okay, sir. See, as far as folk songs are concerned and traditional songs belonging to a particular community, okay, there is the Langa community in Rajasthan. There are so many tribal communities is in the northeast which have their own folklore songs. They are on public domain. See, suppose somebody says there is copyright. Who is the owner? Community is the owner. So whom do you go and apply? Who will go and apply for the copyright? Can the community go and apply, or some individual says I am representative of this, or I am the sarpanch of this community, can I go apply? See, this is a very complex issue. Even today in India, it has not been able to be addressed properly and resolved. Since these folklore songs are available on public domain and belonging to one particular regional, anybody is able to reuse it without violating a copyright, because there is no copyright obtained for these things. But they still belong to that particular community, a tribal community, or you go to the Jarawa tribes in Andaman Nicobar Islands. So many such folklore songs are belonging to a particular community. So there's no one individual composer who says I am the owner of it. They have been there for centuries. We don't know the source of the particular folklore songs also. But as long as they are in public domain, people can reuse it. That's a very complex issue in India today. Even the vast diversities of cultural identities and tribal communities prevailing.
The Supreme Court was in a position to be appreciated. It was paying keen interest in interpreting the expression interested person.
Correct.
The interested person of that particular area may try to apply. That's what the leader's role is required to protect the interests of those people. They are, after all, not aware of what is happening online, and these people who are doing online, even short videos that are made out, and they are trying to encash it, putting them in YouTube, etc. As you have aptly pointed out, the local leaders, they must take initiative to protect them.
A question from Linjuti Bora. He says, recently there are two movies, Rapta and Magadhira. It is absolutely clear that Rapta is copied from Magadhira. Still, Supreme Court decided that there is no infringement of copyright.
Yeah, Magadhira, Rajamouli directed it. Isn't it?
Yes, sir.
And I don't know about Raftar also, but the Supreme Court already, when it is decided, no, that there also, even R.J. Anand case, the theme, the central theme, and most of the scenes, etc., they are copied. That is okay. It should not be complete, say mirroring the same thing is not permitted. Otherwise, it's okay. But because they have also invested a lot of amount, and the efficacy lies with respect to the issue of permitting dubbing, and therefore the producers are now investing. They are forced to invest more by going multilingual, because of this being afraid of the tendency of the court, or the trend of the court is such that it is not accepting that the central idea, the story is borrowed from a particular thing. That's what Prabhas fame picture also that has happened. Original writers total idea and the theme in verbatim is taken and picturized as the movie. There was no remedy available. Anyway, they are almost, at least they are all big people, at least to be taken, to be treated as higher ups, and let us not worry about them. They have their own personal interest, protection of their personal interest by engaging good lawyers like Harish sir, who can win our cases for them.
Okay. So a question from Dusna Haloi.
I think our question and answer session is dominating the sessions.
So many more are coming.
Okay.
Welcome.
I appreciate the involvement of the participants and for so many questions. Okay.
Okay.
If we have more questions, they have understood better.
That's correct.
That's the meaning.
And it is their subject. Owning it up, thereby in this count itself, the webinar is 100%
Successful.
Thank you, sir.
Yeah.
So the question is, if a person has published an article in any magazine, then who will remain as owner of the copyright of the article, whether the author or the publisher of the magazine?
Both, in fact, they have that, and this kind of issue we also face. My articles have been published in many and online journals, but the morale of the particular author, it goes to say that you need to acknowledge, say that this has been the outcome of a particular presentation in a particular national seminar, etc., are already published in a particular domain. Say, for example, you have Liars Club of India, an online website which publishes all kinds of articles, and even in that, the author is expected to have the minimum diligence of putting that particular thing, saying that this has been published and so on and so thing. Because the authors, as authors of articles, we have a small problem, namely ISBN or Blue Book recognition, UGC recognition, etc. At that juncture, there can be duplication of publications. Suppose, say, my article relating to vasting together, it was published in Constitutional and Parliamentary Studies Journal of Constitutional and Parliamentary Studies, and it was also published there in republished there in Liars Club of India website.
Anything you pen down, you get the copyright. You are the owner of that. Anything I write, that is the copyright, the original source.
at that juncture, even the publisher also has the copyright.
Yeah, that's different. But the composer is the author. The owner of the thing is the composer, the man who writes it. Script.
Here there is no recognition or registration done. That is the problem. Yeah.
Okay. Sir, the question from Garima Sethi, who have just question regarding pictures and Supreme Court. So I asked her to make it clear, and she now made it clear the question. So she says, can we use Supreme Court picture within bracket photograph of the Supreme Court in any website? Example, a law firm want to use Supreme Court picture on their website. Can they use Supreme Court picture on their website? Are there any restrictions regarding using Supreme Court's pictures? If yes, then under what intellectual property law it's covered? Do we have to pay a license fee in order to use the same?
So far there is nothing like that, but you are not expected to use Supreme Court picture in your website. It is prohibited, generally known fact, and that comes under the violation of even one may be sued for contempt because it is the Supreme Court's picture. Generally speaking, when we are putting a particular decision pertaining to, say, publishers in the newspapers, they put the picture of the Supreme Court or a particular spokesperson there, like a lawyer, when they publish a particular case or case related matter. Then there is permission, but for a website you can't use anything like that, and there is no specific law which prohibits it. But what I think is there is this sui generis issue which can be taken note of.
The question from Nitin Galot. After an invention is ready for utility in public domain, and then there are grave and harmful aftermath and consequences that come to general public utility. In that circumstances, who will face the liability? The welfare state or the inventor himself?
Both. Suppose say with respect to a patent invention, you are talking about invention, whether it is recognized, registered or not is a question. First it should be registered and then only it should be put to public domain and usage. Here at this juncture you have Carlyle versus Carbolic Smoke Ball Company, even Donovan versus Stevenson. Immediate neighbor is punished.
Ginger beer case.
yeah, that's correct. Both are liable. Not only the public, nowadays the advent of the Information Technology Act, the publishers, whoever publishes such things, if it is hazardous to the public, they are liable immediately, and then ultimately the particular so-called inventor of a spurious and hazardous substance.
A question from Deepavati Brahma. What is the formal procedure of making TRIPS agreement between the parties?
TRIPS agreement. TRIPS agreement is a multilateral treaty, na sir.
Exactly.
It is for the WIPO and WTO to consider, and UN. You should be a country to be recognized.
Nothing to do with individual, I think so.
World Trade Organization members are signatories to the TRIPS. Exactly. Whoever is a member of the WTO, only they are signatories to the TRIPS.
So that particular person who should be recognized as a nation first, and then try for such.
All your intellectual property law in any nation, whoever is a member of the WTO and who is a signatory to TRIPS, will have to align their laws in tune with the TRIPS agreement. That's the system.
I think so, sir. Nothing to do with individual authors, not it?
Yes.
Yes.
Your laws in your country will take care of individual rights and infringements.
Exactly. Sir, Mukhyajit Sunwal is putting a question that I would like to know from you that what practical steps should we take to obtain patent protection?
Patent protection.
Yes.
Suppose for the purpose of South India, you have a patents office situated in Chennai. You need to approach with the proper procedure and show them the particular product. It should be patented. There should be the nuances and other things highlighted, and you need to that will be put in the so-called freezer for some time, and then only there can be hearing objections from others. Whoever is interested, there will be the registration done. For that, the prescribed fee and others are okay, nominal, but there is a lengthy procedure.
I think so. He will be getting the answer more appropriately in Himesh sir's presentation because he will be dealing elaborately regarding.
It's usually on patents.
Yes.
Practice and procedures.
So, Mr. Sunwal.
Actually.
Yes, exactly. It was just an overview session.
Yeah.
Today, online submission of applications is possible because you don't have to run to Chennai to first apply.
Yes,
it's all
sir.
available online. Only to show the product and other things there where you may have to physically be present too.
And in this pandemic, everything is postponed.
Yeah.
Okay. So, Mukherjee Sunwal, please wait for day 3. You will be getting your answer in a very appropriate manner from Himesh.
No, need not be. You just you need to file the application in the proper format.
Online, you can file online. Application can be filed online.
Yeah. What is required is that suppose a particular product is made out, that
shown
every such minute ingredient of that particular product and the nuance that is that should be established there, and then only your application will be entertained, and then it will be going into the so-called dormant or freezing stage.
So, question from Dr. Suranjana Kalita. If a filmmaker makes a film with the story of another film of different language without mentioning the name of that particular film, then is it violation of copyright?
You had already given an example of what is that movie?
Magadira.
Yeah. But by and large, nowadays what the judges are doing, they will definitely look into both the pictures. And first, censor board must be given this particular additional burden of verifying whether there is the so-called plagiarism and copying of the central theme, etc., including central theme also. And I think it is desirable for adding a particular obligation on the part of the board.
Very interesting.
You can register. You can even register a formula like Coca-Cola. Till today, nobody knows the formula. The process can also be registered, not necessarily the product alone. The process also can be registered. The formula is nothing but the process. Till today, Coca-Cola, nobody is able to know who's or the formula at all.
There are certain local companies. In East Godavari district, there is one company almost competing with Coca-Cola, which manufactures that, and it has got I think a subsidiary company of a sugar manufacturing company, and they are making it. A unique Coca-Cola, nobody can.
See, earlier you had Campa Cola. There was a drink called Campa Cola. Agriculture Products Cooperative Society. That is that word Campo. Campa Cola was there, which is today not there. So they were also trying to bring in something like Pepsi Cola, Campa Cola.
So, question from Deepavali Brahma. She's saying that recently China invented apps and software have been removed. According to you, what do you think? Is it a violation of copyright and Patent Act or unfair trade practice?
No. Actually, there is nothing to the so-called companies, these are all amenable to the policy initiatives of a particular company, a particular country or a nation. We have our own sovereign power to allow or disallow, and we have for that matter, suppose say you have what is called the exclusive recognition, the so-called most favored nation status given to, and withdrawal of that, and it goes to the question of sovereignty of a particular nation, and in public interest that is being done. Even if you are questioning it, you don't have a fundamental right to recognition or imposing ban on a particular thing, because in public interest only it is done.
Okay, sir. From Dr. Mosumi Kalika, whether buying an original work means we are acquiring the copyright in it?
Original?
Yes, sir. Whether buying an original work means we are acquiring the copyright in it?
Definitely, and it depends upon the facts and circumstances of each case. Work means what kind of work is it? If it is worth copyrighted, definitely when you are buying, you have an agreement with the particular maker, and that is what is happening with respect to so many companies and firms. Where, say for example, in Gendu Pharmaceuticals, you have many scientists working there, and they have a target to produce original works, and it is obviously bought by the companies, and the company exercises that right and enjoys the right. And as far as individual is concerned, you don't have a possibility to breach the contract when you are doing something for them, or when you are selling it to somebody. That's how stories written by several authors, they are sold to the producers.
Okay, sir. So probably this is the last question, and that question is very, very related and specific to Assam, sir. The question is by Amrita Priyam. The gamusa that is considered to be a privileged part of Assam are generally hand-woven by the weavers of Assam with lot of efforts in it. But now it is being machine weaved by some other states and sold back to Assam in cheap rates. Is it not infringement?
It is if gamusa has been registered. Say for example, in Karnataka also we have a particular kind of sarees made, handloom sarees made in near Hubli. What is that area, Harish sir?
Ilkal sire, Ilkal sarees.
Ilkal sarees. I also bought them. I have gifted it to my half-heart for her surprise, because generally I don't buy anything for her. by the way, that is GI recognized. What gamusa or the people associated with that handloom weaving community, they need
Bagalkot. Ilkal is Bagalkot.
GI is the solution. And now machine made things, they are there until you get this kind of GI recognition or tag.
Hallmark, the silk mark, you have all these things. On sarees, you have the silk mark.
That's correct.
Yes, sir. I think so.
Does that.
The geographical indication is a solution, I think.
Yes.
So there is no other question left out.
Is it necessary to be registered getting protection under IP rights? Yes. How to get protection if not registered? If not registered, you don't have any such protection possible, and unless you are an author of a particular book or anything like that.
So participants,
in Silk Mark, you have the Silk Mark Organization of India, which gives the recognition for the Silk Mark for all the silk sarees.
Yeah, Silk Board, our Silk Board.
Yeah, no, Silk Mark Organization of India, there's a body which gives you license for putting the Silk Mark.
Yeah. Oh. There's another body.
Yeah, there's a body for that.
Harish sir,
Yes.
just a question from me, just a confusion, sir.
Which one? No, I am just telling you
sir,
there's
just
an
a confusion.
organization by name Silk Mark Organization of India.
Sir, whether it will be coming under the Geographical Indication Act?
Which one? Silk Mark?
Yeah, Silk Mark Organization.
No, you don't have such categorization. Anyway, that Harish sir only.
No, anybody can apply for it and obtain if you want, if you are so popular geographically in that area. Suppose, see, in Goa, some of the liquor is only sold in Goa, it's not sold outside.
Yeah.
Some of them is manufactured only in Goa. So geographically also, see the geographic indication, anybody can apply depending on you fulfill their requirements and satisfy the compliances.
It should be unique. It should be unique.
Unique, that's what.
And they would definitely search whether there is Mysore in Mysore board.
Goa penny is unique. Goa penny is unique.
Yeah, that's correct.
That's why I said Goa.
It's made of cashew roots.
Yeah. You get coconut penny, cashew penny, variety of pennies available in Goa.
We are teetotalers, sir. We don't have any.
Sir, sir, there's a thing in a court in Karnataka High Court. There was a matter on UB going on, where some UB cork manufacturer subcontracting had been given. The advocate appearing for the cork manufacturer had appeared had failed to pay some taxes, I think so, on contract tax and sales contract. So Justice, I don't know which High Court judge, probably it was Justice Rajendra Babu. The counsel was asked by the judge, I'm given to understand. I mean, the UB is the best beer in the world. So the counsel appearing for this cork manufacturer said, "Sir, I am a teetotaler. I don't know."
Yeah,
so the judge immediate repartee was, judge said, I too am a teetotaler, but I still know that it is the best beer in the world. So no fact you don't know, you did not drink. Because there are surveys which will give you the information.
Many people saying that this
information of a good or a bad thing is divine. Experiences may be devilish. Information that there is statutory warning on the cigarette pack, injurious to health, is a good information about a bad habit. But the information is still good. To know that drinking is injurious to health is a good information.
Harish sir?
Yes, thank you.
Sir, am I audible to you?
Yeah, I am able to hear you.
Sir, actually you said something regarding patent society, not before while answering some questions.
No,
you said something about patent society.
Performing Rights Society of India.
Okay. So just my question is
that
whether
copying your CDs, taking that's a society which takes care of royalties collection to be made to people who are singers, authors, composers of music, lyrics. That's the society.
So it is so whether it is similar to that of the Copyright Society, sir?
No, it is not. It is not similar. This is a governing body that is created by the performers, so that they don't have to every now and then go and ask royalty from each person who is using their works. So this society is a intermediary agency which will take care of this and regulate all these things, giving licenses to them to use their works and to pay royalty. Suppose a company wants to duplicate CDs of a corporate company wants to, for its 25th anniversary, wants to duplicate CDs of songs sung by Lata Mangeshkar exclusively and give it to all its clients, vendors on the occasion of Silver Jubilee, then you need to take permission from this, because you are duplicating that. See, that's why it's perform. You'll have to pay royalty to them. They will then pass it on to the original authors. That's the Performers Rights Society of India.
Okay, sir. So it was a personal question from my part, sir.
Yeah, no, personal, public, all the same for me. And if I can answer, I will answer.
Okay, sir.
Always welcome.
So just a question, I'll just like to say to all the participants that whatever questions have been put in the chat box, I have already forwarded it to the resource person, and hopefully both of our esteemed resource person have clarified those questions and given the answers up to our satisfaction. So my last query to all of you that if you want to directly communicate with any of our resource person, you can just raise your hand and we can unmute you so that you can directly put your question to our resource persons. Anyone? Gautami ma'am, do you want to ask any question? I'm actually seeing a raising hand. Okay, I'm unmuting Arjit Kundu. You can ask your question.
Yeah, am I audible?
Yes, you are audible, but you are not visible. Please switch on your camera, sir. Okay. What's happening? Arjit sir?
Yeah.
Yes, we are seeing. You can put your questions.
Yeah, I wanted to ask the respected sirs that what is the position of law regarding Indian epics like the Ramayana or the Mahabharata? So, if anybody wants to remake on those things, what is the current legal standpoint on that?
Harish sir? Can you please repeat the question?
Yeah, I can. Yeah, uh, so my question is that what is the legal point or the legal standpoint that regarding the remaking of movies or writing a book on the Ramayana or the Mahabharata? For example, if I want to write a book on the Ramayana, so do I have to approach anybody for uh, copyright or something like that?
Thank you, sir. I got it, sir. Harish sir?
Prosenjit, let me call Mohan Rao sir. Maybe some network issue.
No, Mohan Rao sir is already been entered. I have already entered.
Okay.
You can please
Let
add
me call
Harish sir. You can please add Harish
sir.
sir.
Harish sir is not there, sir. Please tell Harish.
Bola sir? Are you hearing me? Am I audible to you, sir? Hello? Hello?
Prosenjit, unmute Bolla sir.
Bola sir have been already unmuted. I have made it co-host.
Sir, you are.
Sir, you are co-host. You can unmute yourself.
Sir, please unmute yourself, sir.
Not finding out, sir. He got disconnected. Bola sir got disconnected.
Okay, Prosenjit, Bolla sir is getting reconnected, but he is not able to enter.
Okay.
Some problem, the network issue.
Oh. What about Harish sir?
And sir, what about Harish sir?
I'm not seeing him.
Prosenjit, please ask the participants to kindly hold patience for at least few seconds.
Okay. They are hearing. They are hearing. So there are some technical issues. Please cope up with that. Okay.
I think I can rejoin now.
Yes, sir.
Harish sir is not responding to call. Okay. What is the question? Is it for him specifically?
No, it's not like that, sir. You have not put any questions specific, sir. It was an open question to both.
That's okay.
So the question was that in case of Ramayana, Mahabharata, that is the Vedic books or whatever it may be, the ancient literature. Yes, sir, epics. So if today I decide, the question is that if today I decide to write a book, okay, sir, Harish sir is here, I'll just make him.
Yeah. Okay, no problem. You go on with the question.
I'm just making him co-host. Harish sir, now you are co-host, you can unmute yourself.
Yeah.
Yes, sir. So the question is that in case of epic books like Ramayana, Mahabharata, or whatever it may be, if tomorrow I decide that I will write a book on Ramayana or Mahabharata, whatever it may be, or if I think that tomorrow I'll go for a drama or make a movie or make a serial or whatever it may be literary work or any other thing. So in these cases, from whom I shall take the permission? Is there any authority to whom I should approach?
Relating to Ramayana.
Yeah.
Anybody can do that, and you need to produce the movie and then approach the cinematographers under the Cinematographers Act. You have the procedure for censorship, etc., and then do that. And even suppose say there was a book called Ramayana Vishavruksha, criticizing the Ramayana. You have a right to expression guaranteed as a fundamental right. Tomorrow, if you are taking a decision to write a book on Ramayana, it's okay. Your own interpretation, it can be appreciated for provided you do not offend anyone's feelings.
Lot of people have written on Ramayana. C. Rajagopalachari, the first and last Governor General of India, has written Mahabharata.
Yes.
So,
and that's his own version.
Yeah.
Rajagopala is Mahabharata. So also when Bhagavad Gita, you have several such authors, including C.D. Deshmukh.
Union Minister Veerappa Moily has written on Ramayana, I think.
Yes. Perhaps. There's no problem in that. Producing a movie, you have to undergo the process of cinema under the Cinematographers Act.
Okay, sir. So the Nitin Gahlot. Yes, I am just unmuting you. You can unmute and put your question directly.
It's not Nitin Gadkari.
No, it's not Nitin Gadkari. Nitin Gahlot, are you hearing me? I am attempting to unmute you. You can unmute yourself.
Mostly similar
Gautami Datta has come.
Prokanjit,
Ma'am, you can put your
Prokanjit.
Yes, ma'am.
Okay, okay. I have a question that if a startup develops a social network,
Yes, ma'am, you are audible.
Social network.
Ma'am, I think so she got disconnected. No, she is there. Ma'am, please unmute yourself.
okay, okay. Can you hear me?
Yes, ma'am, we are hearing.
Oh, okay. If a startup develops a social network of its own, mostly similar to that of Facebook, is it possible for the startup to claim patent on the for his development?
Patent.
If anybody develops a social network similar to that of Facebook, can that person can claim patent for that new development?
Definitely, why not? The patents authority will verify whether there is any problem with respect to the so-called supposed name you shall not use. Similar networks are permissible. Approach the international forum for domain recognition. That is the only problem.
Are you sir?
Say for example, you have what is called elements similar to that of Zoom. What is suggested even by Ravi Shankar, a guru, and even there are some who are trying to encourage that elements just similar to that of Zoom. You have similar service agencies like WebEx, etc., even available in the international forum. If a local entrepreneur comes forward to do something similar to that of Facebook, nothing comes in the way except to purchase a domain name and website designing.
Okay, sir. So
I think I have answered Gautami Datta's question.
ma'am, I'm unmuting you.
Yeah, she is there.
Thank you.
Yeah.
Thank you, sir.
Good.
Thank you very much.
Good. Had you been that particular person initiating to start a similar website like Facebook?
No. I am not that particular person. He is something that somebody different.
Okay, good.
Thank
good.
you, sir. Thank you.
Good question. Yeah,
Okay, I
Prasenjit.
think so. We have I think so. We have ended up all the questions. There is no raising hand. There is no queries. I have not seen anything in the chat box for last few minutes. But still, there is a last option. If anyone want to ask any question, you can please raise your hand. You can directly communicate with our resource person.
Except that when will you wind up the session?
Sir?
Accepting a question
I'm not
like as
reading
when
your
will the session? Okay. Questions are welcome.
There might be some network issue. So no question, sir.
Yeah.
No question.
Thanks very much for giving us an opportunity. Wonderful. Done well, wonderfully well, especially the question and answer session with the intervention by Harish sir as added silver lining for the program. Thanks very much.
Thank you for having
Thank you for the patient listening and hearing and participation to each one of the participants. And special appreciation to Preeta and Prasenjit.
Sir, thank you, sir.
My appreciation to Preeta and to Prasenjit. Okay, nice meeting you all.
Sir.
Yes, madam.
Sir, thank you so much for joining.
Pleasure. Always. You can always get in touch with me for anything. Whatever I know, I can always share.
I have noted your email ID as well. I will of you sometime.
Gupta, for your kind information, sir was instrumental in getting our students bagging the winners prize in the parliamentary
Model
debates.
Parliament competition.
Parliament
Model Parliament competition.
Model Parliament competition.
Okay, nice, sir.
Yeah,
I
you
train
can
students in parliamentary procedure by conducting model parliament for law students the last 30 years.
Yes.
Yes, sir.
And sir is well known for that. You might utilize his services in that regard.
And model UN also.
We'll look
Model
forward.
UN we'll try, sir, here. And even I think we can coordinate with these two colleges.
Yeah, last
Yes, sir. Definitely.
last week I was the chief guest inaugurating the first virtual Model United Nations in Delhi Public School, East Bangalore. First virtual one, online.
Okay.
I was the chief guest who inaugurated that online. Right.
Definitely,
we
we
are
will also
very
happy.
keen on we are very keen on training rather than the so-called inauguration of virtual platforms, but we go for training online.
In 1997, Prita, in 1997, I had conducted a national model parliament competition in Delhi when P.S. Sangma was the speaker. After the program, I took the students to P.S. Sangma's house for a tea with him to meet him. That time his daughter Agatha Sangma was a small little girl.
Okay.
That was because 50 years Golden Jubilee India's Independence Day celebration. From all 25 states, we had made 20 students to come from each state to Delhi for a 10 days training to do a national model parliament program of 2 day session.
I think a similar thing must
I've
happen.
written a book on the parliamentary procedure on that occasion, which was which is published.
Okay, I will contact you for that about the information of that book, sir.
You have YMCA in your part, so they are the ones who are coordinating with me to do these things. They will host it also.
Mohan Rao, sir, good to see you after 6 years.
6 years, 6 long years.
6 long years.
And we have special appreciation to Preeta for several reasons, including the fact that you are the secretary of your own Kakrajar or
Kokrajar.
A unique place in Bodoland.
Bodoland, sir.
A unique place in Bodoland, and I did not have this kind of information about you at that time. Very good, very good.
Pleasure, sir. Pleasure.
Yeah.
Thank you, Professor Bolla, sir,
Thank you, sir.
for giving your precious time to us and for your wonderful deliberation regarding the various aspects of intellectual property rights. Because, sir, just my point is that this first session was very, very important, and I hope so. Whatever we thought, it have been achieved, because it is this session through which the participant can open their doors. That what are the various subject matter of intellectual property rights, because the next 4 days are directly on some specific subject matter. It will not be an overall or in general regarding intellectual property rights. So I think so you have helped all the participants, including me and the organizing committee, to know the various aspects of intellectual property rights. You have cited so many case laws that are basically recent in nature of the Supreme Court, Honorable Supreme Court. You have given insight regarding all the patent, copyright, and all those things. So now the participants will be happy, and they will also be coming to know that what are the things that we will be learning in the next 4 days. Because I would just like to inform you, sir, because the participants are multidisciplinary in nature and all from law background. So many participants are there who are students who have not studied the intellectual property law till yet. There are various research scholars from other subjects like English, political science, and all those things. There are faculty members from mathematics, philosophy, then chemistry and physics. So they do not know anything about intellectual property law. This is what I presume. And actually, today's your insightful speech was very, very good. And I actually thank Harish sir, who have joined you, and he has actually spent his precious time with us by helping you in giving the answers. And also, I also learned so many things with him. So thank you to both of you, sir. And with the hope that yes.
Theory on one coin, on one side of the coin is theory, and the other side is practice. Practice made.
We both are two sides of the same coin.
Okay.
We both are two sides of the same coin.
Yes.
Okay, sir.
So we supplement and complement each other in our deliberations.
Endeavors in fulfilling
Okay,
this task of making legal education an excellent avenue for anybody, and I congratulate each one of the students of both the colleges and the various participants from various universities and colleges. Thank you very much.
Thank you so much.
Thank you.
Thank you so much.
All the best. God bless you.
Okay.
All the best.
Okay, ahead, sir.
We'll continue our efforts in making the other events also more successful.
Okay, definitely, sir. So we have a hope that we'll be meeting you physically, sir, soon.
You ASEAN people should become as sharp as your most spiciest chili, Boot Jalokia.
Okay, sir. Okay. Okay. Thank you, sir.
Bye, sir.
So, dear participants, we have a
And
little bit
I think
announcement.
we are going to get the link for the next programs also.
Sir, definitely,
Yes,
definitely. You will be getting it. You will be
Yeah.
getting it
We
for
will
the
try to
next
be
4
there.
days. You will be getting it for the next 4 days, and whenever you feel comfortable, you
We'll
can
join.
definitely join. You can interact with the participant. You can interact with the other resource person, and it will be very helpful for us for a very fruitful discussion, sir.
Thank you for
Bolla
that.
sir, we need to go to their college one day to
Sir, definitely, we will
We
welcome
look
you.
forward for that. We look forward for that, and we'll do that.
Okay,
Welcome,
sir.
sir.
Okay.
Welcome.
Because Preeta is all in one, and she can make all such efforts. And I think very near future we need to attend her marriage first, and then look for.
Satya,
I can
Satya.
offer you to, I can do one thing on parliamentary procedure and constitution and things like that to you all online.
Okay, sir.
Definitely, sir. We will plan to do it, sir.
We'll
Yes,
talk about it,
yes.
sir.
Okay, sir.
Thank you very much.
So,
Thank you. Thank you.
thank you, sir.
We take leave of you.
Okay, sir. So, dear participants, you will be getting soon the link for giving your feedback for our resource person of today's session. Apart from it, you will be in the same link. You will be getting the few questions that need to be answered by you all, and you need to submit the feedback form along with your questionnaire till within 4 o'clock. I think so. Yes, within 4 o'clock.
Answered
So
questions.
please, yes, sir.
Answered questions with
Yes,
answered
answered
questions.
question. Yes, sir. Answered question till 4 p.m. today, sir.
Yeah, they are
Okay.
MCQs, multiple choice questions.
Dr.
Have the answers therein.
Sanjay,
Yes,
Dr.
sir.
Bolla sir and me are
Yes,
like
sir.
academics in action. He is academics, I am in action.
Okay.
We are academics and action. We are two sides of the same coin. So both
Okay, sir.
theory and practice together.
Yes, sir. Yes, sir. Yes, sir. Okay. Thank you, sir. Thanks a lot.